Hey there, welcome to Help Solve the Case. I'm Christine Burke, and today, if you're watching these all today, you're going to see three videos from me and hopefully a fourth, although I may not because all heck is breaking loose. I may not get to the Lindsay Clancy trial today, but that is the reason that I'm here talking to you now. And so there'll be three, there may be four, but we have another. It's arising, I believe it got triggered from the Lindsay Clancy case. I'm not sure at this moment that I'm right, but this is part of where I want to share this with you on the channel because these cases and the proper application of court procedure, the Constitution, and all of that is so important. And that's why I like to get this information out as soon as it hits. In the Lindsay Clancy case, and this is why I like doing the play-by-play. I like watching it real time, and I don't just like some people may do the transcripts, get the tidbits, get the cliff notes. I don't do that because I want to see body language, I want to have continuity, and I want to know what is going on. The defense kept bringing up this lab, NMS Labs. And it seemed like every time there was a sidebar, it was mentioned. Of course, we didn't hear what happened. And again today, there was twice. And then the subject changes. And today, they're talking about toxicology. Today, I had enough and I said something. Why is he trying to get this lab in? And I will talk about it, interviewing the witnesses. They were like, ma, 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 ma. You can tell if you watch a lot of these, you're experienced in the courtroom stuff. You can tell when some tea is about to be spilled and some stuff is going down. So I said, what is this lab? What the heck is this lab that he keeps talking about? Today, with this last witness, and I'm not finished watching yet for today, he was like, NMS Labs. You know what that lab is, right? You've heard of that lab, right? Pennsylvania. I said, okay, I've had enough. We're going to check it out. Here we are. And so I go to this page and I'm like, okay, it's a triangle or a pyramid. And it says, when you need to know. And I'm like, okay, when you need to know, innovative, esoteric toxicology solutions. My investigative mind is like, what is going on here? I go down, I'm like, okay, drugs, normal, looks like normal stuff, solutions. I'm looking at this stuff. I'm like, okay, looks like normal drug testing to me. I don't see an explanation of what the N, the M, and the S is. Who we serve, attorneys, crime labs, law enforcement. I'm like, okay. And then I went to the resources page and I see Smith v. Arizona. What is that? And it talks about, of course, it has to be Arizona, right? You know, Miranda. Here we go. Smith v. Arizona. And it starts talking about, and I will tell you, I have not gotten into all of this. I'm going to take some time, but I want to put it out here because I'm not sure if the defense attorney is communicating something or trying to communicate something or preserving a record or something. And these things get mentioned and the precedent can affect the other cases. For instance, the transcription stuff that came up in Pamela Smart. I have shared that with some of my clients because I believe it's important. And I started looking at it in my cases. Has it impacted my cases? Just because I'm not an attorney doesn't mean that I can't look at this stuff. I'm an investigator, so I'm going to investigate it. So I started looking at all this stuff here, and it says Supreme Court. I said, uh-oh, 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 uh-oh. I started reading this stuff, and I was like, let's just talk about this. By now, all of you have likely been affected by the United States Supreme Court's ruling in Smith v. Arizona. Supreme Court docket number 22-899, decided on June 21st, 2024. The Smith decision follows the court's prior decision in Williams v. Illinois, Bull Cumming v. New Mexico, Melendez-Diaz versus Massachusetts, and Crawford v. Washington, the latter of which was decided in 2004. Each of these decisions set forth guidance and parameters relating to an accused's right to confront witnesses in criminal proceedings under the rights granted by the Sixth Amendment. And I started flipping through this, and I was like, oh, please, I need my assistant to help me. So I came over here. Here's what ChatGPT says. I don't know if it's right. I don't know if it's wrong. I haven't read the whole thing, but I feel that this might somehow be important. So I'm making a video, and we're going to go through it. Here's what Chat says. I call him Chat. The gist. This is not a page admitting that NMS Labs did anything wrong. This is saying courts should not automatically require every employee who handled or tested a specimen to appear. A qualified toxicologist may still review the laboratory materials, form an independent opinion, and testify, provided the witness is not merely repeating testimonial statements made by absent analysts. Now let's go to Tyler Robinson. And when we were talking about, this is how my mind works, I was talking about the fact that the independent witness, the expert, was hampered within a set of guidelines from their agency about what they could say and what they couldn't say, because an expert usually gets to form their own independent opinion, and they should not be throttled on that, to my understanding. Here, we're talking about a toxicologist specifically, but this can apply. These precedents get set and they get applied across disciplines. Is this something we should be paying attention to? They may still review the laboratory materials, form an independent opinion, and testify, provided the witness is not merely repeating testimonial statements made by absent analysts. I'm not the lawyer. This could involve hearsay. But what I believe it's saying right here, and you guys who are in the biosciences, many of you follow this channel, maybe you can quote this and help me out here. What I feel that this sentence is saying, so if you can talk about, like if it said we were listening to some testimony, 8 milligrams of this, 4 milligrams of this is the type of test that was used. I'm thinking about those reports and not just in the Tyler Robinson case. I'm thinking about these reports. I'm also thinking about, because this is how my mind goes. So I know we haven't even got past this first statement. But think about this. Think about all these experts that we see testify. Think about Tyler Robinson, where they were reading notes. They were reading notes. Are notes testimonial? I don't know. I'm not up on the hearsay objection and all that stuff. My lawyers that are here, whatever. Let's keep going. Again, I'm just throwing this out here as soon as my mind started going with it, because he's saying it for some reason, and this could not even be the reason. I don't know. I have no idea. So Chatty says that is partly correct because NMS said that, but the page is also clearly presenting NMS Labs' preferred legal interpretation. It is not a binding judicial ruling. So NMS is interpreting the Supreme Court ruling. Here's what Chatty is saying, what Smith v. Arizona actually held. In Smith, Chatty's going to try to explain it to us. In Smith, one analyst performed the drug testing and documented what she did. Now, remember, we hear with all these lab things, some people collect the stuff, it goes to the lab, people run the testing, other people are hopefully verifying it, and then they put it in a report. The tech lead and all this stuff that we heard, there's other people confirming it and going through this process. In Smith, one analyst performed the drug testing, documented what she did. She was unavailable for trial, so a second analyst testified about her procedures and results, and then called his conclusion an independent opinion. The Supreme Court rejected that workaround. It held that when an expert repeats an absent analyst's statements, are those note statements? And the expert's opinion is dependable only if those statements are true. The statements have effectively been admitted for their truth. If they are also testimonial, the defendant generally has a constitutional right to confront the person who made them, which is true. I believe this issue was being raised with the 1102s, and I don't mean to keep throwing that case in here, Tyler Robinson, with the 1102s, that the 1102s were coming in instead of direct testimony. But if I remember correctly, and y'all can correct me if I'm wrong, you all can correct me if I'm wrong, they were saying that hearsay was different in a trial than during a preliminary hearing. Again, this is about constitutional rights. In ordinary language, the prosecution cannot put scientist B on the stand to say, scientist A received this specimen, prepared it correctly, ran these tests, obtained these results, and therefore I agree with scientist A, while scientist A remains unavailable for cross-examination. We have to think about, has that happened, whether it's toxicology or not? This is things we need to think about. These are how the precedents are applied. Calling scientist B's conclusion independent does not solve the problem when scientist B must assume, there's that word, that scientist A accurately performed and documented the critical work. What Smith did not say, it did not establish that every person who touched a vial, transported a package, entered data, maintained equipment, or performed an administrative review must testify. The court specifically recognized that some laboratory records may not be testimonial because they were created primarily for equipment maintenance, accreditation compliance, internal quality assurance. That might be the tech lead, not sure. Routine administrative processing, scientific literature, or reference databases. Those records may have a purpose independent of prosecuting a particular defendant. The analysis must be made record by record and statement by statement. What NMS Labs is trying to accomplish with this page. The most important paragraph on the NMS page is where the company says its records are created primarily to satisfy scientific accreditation, licensing, and quality management requirements, not primarily, quote, with a focus on court. And that one I did see on the page, and that, where is it? Some of NMS Labs reports do end up in court, but NMS Labs does not perform its world-leading quality work, quote, with a focus on court, end quote. They say Our accreditations, certifications, and federal and state licensing credentials provide the gold standard on which we based our testing. Those external systems inform the drafting and implementation of the NMS Labs standard operating procedures, quality control measures, and systems for quality management and their continuous quality improvement. Our level of quality and excellence in receiving, processing, preparing, testing, and reporting processes and conclusions inform and drive the work of NMS Labs in clinical, forensic, and environmental testing alike. NMS Labs' primary purpose is to maintain the integrity of the scientific processes and results in all fields of testing, and the primary purpose for every single decision and supporting record is adherence to the highest scientific and quality management standards. What does this mean to us? It says NMS's proposed solution, and again, this is ChatGPT saying it. I don't know, accurate, whatever. I'm just reading it because I'm trying to understand what's going on here with the court case and why this is being referenced. A laboratory cannot make evidence non-testimonial merely by publishing a policy stating that its primary purpose is accreditation or scientific quality. A judge must examine why the particular test and particular statements were created. For example, okay, he's going to give us an example to the case. A machine maintenance log created monthly for accreditation is different from an analyst notation that I received blood, prepared it in this manner, ran this test, and identified these substances. The latter statements may exist specifically to establish what happened to evidence in a criminal investigation. Okay, here we go. Massachusetts has already applied Smith. They already had a case come down where this is precedent, or where it was used as a citation. The Massachusetts Supreme Judicial Court addressed Smith in Commonwealth v. Gordon in September 2025. Not yet a year. In Gordon, the original analyst performed drug testing, but a laboratory supervisor testified after reviewing the original analyst's work. The Massachusetts court held that the substitute's opinion depended on the truth of the absence analyst's statements about what she did. The conviction was vacated, big words, the conviction was vacated because the defendant had not been able to confront that original analyst. And I'm wondering if this goes to impeachment of the witness when it talks about true statements. One of the things that you try to do is impeach the witnesses on both sides. The Commonwealth argued in Gordon that the original analyst notes existed for accreditation, internal review, and quality control. The same general theory NMS advances on its webpage. The Massachusetts court nevertheless focused on the actual circumstances. Law enforcement had submitted evidence for testing intended to establish an element of a criminal offense. Oh, man. The lab's general accreditation purpose did not automatically remove the confrontation problem. So, in the Clancy trial, the defense's reference to NMS are probably not accusations that NMS produced bad science. They concern who actually performed each portion of the blood testing, who may testify about those results, whether the defense will insist on confronting each necessary analyst, what facts Clancy will stipulate to, and how much of the lengthy laboratory foundation the Commonwealth must present. I will tell you that he was going, and I haven't given you the play-by-play yet for today. He was going through, they did say that they sent stuff out to another lab. So the question would be, I'm guessing, are they relying 100% on the lab reports that were done in the state police and not lab reports that were sent out? Maybe that's what he's trying to get to when he says, are you familiar with NMS? Do you send lab materials out to a different lab? Maybe he's trying to determine what each expert is basing their answer on. I know that they had some questions about their machine could determine that a chemical, a drug, a chemical, and its metabolites were present, but they could not give a specific, the way I understand it, a specific quantity. I'm wondering if the state is going to use that, because if we think about it, the Commonwealth keeps trying to minimize the drugs, all the prescription bottles. She didn't take that many, she didn't take that many, she didn't take that many. Cuts were superficial, because the state has to prove the intent, the criminal intent was there, that it wasn't diluted by, and by diluted, I don't mean by a substance, but it wasn't diminished by diminished capacity or some type of mental thing that was going on. I think this is very interesting. I'm not sure why he keeps referencing it, but I think when we're going to have cases that we're going to watch, including toxicology and other types of testimony, I believe it could apply. Just because this one is toxicology doesn't mean that a good attorney won't try to apply the notes. The basis of it is not toxicology. The basis of it is the Sixth Amendment right to confront a witness against you, the hearsay rule, and what is testimony, and whether the accuracy of the original person notes or findings or opinion is truthful. And without the ability to confront that, again, not a lawyer, that's what I'm trying to say. So not saying anything against the lab or anything like that. Do your own research, whatever. We're just trying to understand why this keeps getting mentioned. As we go through these cases, all these precedents and case laws, that's how we keep applying these case law throughout these cases to see, is the Constitution being applied properly? And more so, as we keep getting more technology and different things, how do we account for that when it's not in the original? Way back in the day, they didn't have all these things that they have today. They didn't have these technology and things. We have to keep that in mind. And this is what I feel is so important. I could be totally off base, but I think it's an interesting precedent that we need to be aware of for other cases that we're watching. I need to go back and see if I can find out what he was digging around about. I'm assuming it was, that's a bad word, but I'm assuming it was because where did the defense attorney get the name of the lab? Was there an invoice? Was it sent out there? Do they have lab results that he's just trying to make sure they're not testifying to? Or is it just that he's in Massachusetts and he knows that stuff normally goes to that lab? Look at Pamela Smart's appeal. How many years later, years and years and years later, a transcript, something I didn't even realize was a problem, although I did have it as a problem in my case and I had to get the transcript corrected. I asked for the transcript to be corrected, not even thinking about a bias problem. These are all good learnings. This is what I'm here for. I hope this is what you're here for. I hope this has been educational. Let me know, you guys that are working on the benches and working in the labs and doing all this stuff, any attorneys, whatever, did I get it right? Did I get it wrong? We'll see what happens. And I got to get back to watching. I'll see you on the next one.